I. Commencement of Act. The provisions of this Act shall come into operation on the 24th day of October in the year of our Lord 1852. 2. Personal actions, when defendant resides within the jurisdiction, to be commenced by writ of summons in Form No. 1 of Schedule A. All personal actions brought in Her Majesty's Superior Courts of Common Law, where the defendant is residing or supposed to reside within the jurisdiction of the said courts, shall be commenced by writ of summons in the form contained in the Schedule A. To this Act annexed, marked No. 1, and in every such writ and copy thereof the place and county of the residence or supposed residence of the party defendant, or wherein the defendant shall be or shall be supposed to be, shall be mentioned, and such writ shall be issued by any one of the officers of the said courts respectively by whom like process hath been heretofore issued from such court, or by such other officer as the court shall direct. 3. No form or cause of action to be mentioned in writ. It shall not be necessary to mention any form or cause of action in any writ of summons, or in any notice of writ of summons, issued under the authority of this Act. IV. Writ to state names of all defendants, and for only one action. Every writ of summons shall contain the names of all the defendants, and shall not contain the name or names of any defendant or defendants in more actions than one. V. Writ to be dated of day of issuing, and tested in name of Chief or Senior Judge. Common Law Procedure Act 1852. Common Law Procedure Act 1852. 1852 Chapter 76. An Act to amend the process, practice, and mode of pleading in the Superior Courts of Common Law at Westminster, and in the Superior Courts of the Counties Palatine of Lancaster and Durham. 30th of June 1852. Whereas the process, practice, and mode of pleading in the Superior Courts of Common Law at Westminster may be rendered more simple and speedy. Be it enacted by the Queen's most excellent Majesty, by and with the advice and consent of the Lords Spiritual and Temporal, and Commons, in this present Parliament assembled, and by the authority of the same, as follows. Writs for commencement of actions. And with respect to the writs for the commencement of personal actions in the said courts against defendants, whether in or out of the jurisdiction of the courts, be it enacted as follows. Back to full view. Previous next. Every writ of summons shall bear date on the day on which the same shall be issued, and shall be tested in the name of the Lord Chief Justice or Lord Chief Baron of the court from which the same shall issue, or in case of a vacancy of such office, then in the name of a senior point judge of the said court. Vi. Writ to be endorsed with name and abode of attorney, or a memorandum that writ has been sued by plaintiff in person. Every writ of summons shall be endorsed with the name and place of abode of the attorney actually suing out the same, and in case such attorney shall not be an attorney of the court in which the same is sued out, then also with the name and place of abode of the attorney of such court in whose name such writ shall be taken out. And when the attorney actually suing out any writ shall sue out the same as agent for an attorney in the country, the name and place of abode of such attorney in the country shall also be endorsed upon the said writ. And in case no attorney shall be employed to issue the writ, then it shall be endorsed with a memorandum expressing that the same has been sued out by the plaintiff in person, mentioning the city, town, or parish, and also the name of the hamlet, street, and number of the house of such plaintiff's residence, if any such there be. 7. Attorney on demand to declare whether writ issued by his authority, and to declare name and abode of his client, if ordered. If writ issued without authority of attorney, proceedings to be stayed. Every attorney whose name shall be endorsed on any writ issued by authority of this Act shall, on demand in writing, made by or on behalf of any defendant, declare forthwith whether such writ has been issued by him or with his authority or privity. And if he shall answer in the affirmative, then he shall also, in case the court or a judge shall so order and direct, declare in writing, within a time to be allowed by such court or judge, the profession, occupation, or quality, and place of abode of the plaintiff. On pain of being guilty of a contempt of the court from which such writ shall appear to have been issued, and if such attorney shall declare that the writ was not issued by him, or with his authority or privity, all proceedings upon the same shall be stayed, and no further proceedings shall be taken thereupon without leave of the court or a judge. 8. If writ issued without authority of attorney, proceedings to be stayed. Endorsement of debt and costs on writ and copy of writ for a debt, with notice that proceedings will be stayed on payment within 4 days. Upon the writ and copy of any writ served for the payment of any debt, the amount of the debt shall be stated, and the amount of what the plaintiff's attorney claims for the costs of such writ, copy, and service, and attendance to receive debt and costs, and it shall be further stated that upon payment thereof within 4 days to the plaintiff or his attorney, further proceedings will be stayed, which endorsement shall be written or printed in the following form or to the like effect. But the defendant shall be at liberty, notwithstanding such payment, to have the costs taxed, and if more than 1/6 shall be disallowed, the plaintiff's attorney shall pay the costs of taxation. IX concurrent writs may be issued. The plaintiff in any such action may, at any time during 6 months from the issuing of the original writ of summons, issue one or more concurrent writ or writs, each concurrent writ to bear test of the same day as the original writ, and to be marked with a seal bearing the word concurrent, and the date of issuing the concurrent writ, and such seal shall be provided and kept for that purpose at the offices of the masters of the said courts, and shall be impressed upon the writ by the proper officer of the court out of which the original writ issued, provided always, that such concurrent writ or writs shall only be in force for the period during which the original writ in such action shall be in force. X. From commencement of this act certain provisions of 2W4 circa 39 repealed. Single quote. From the time when this act shall commence and take effect, so much of a certain act of Parliament passed in the 2nd year of the reign of His late Majesty King William IV, intituled an Act for Uniformity of Process in Personal Actions in His Majesty's Courts of Law at Westminster, as relates to the duration of writs, and to alias and plures writs, and to the proceedings necessary for making the first writ in any action available to prevent the operation of any statute whereby the time for the commencement of any action may be limited, shall be repealed, except so far as may be necessary for supporting any writs that have been issued before the commencement of this act, and any proceedings taken or to be taken thereon. 11. Renewal of writs of summons to save the statute of limitation, and for other purposes. No original writ of summons shall be in force for more than 6 months from the day of the date thereof, including the day of such date, but if any defendant therein named may not have been served therewith, the original or concurrent writ of summons may be renewed at any time before its expiration, for 6 months from the date of such renewal, and so from time to time during the currency of the renewed writ, by being marked with a seal, bearing the date of the day, month, and year of such renewal. Such seal to be provided and kept for that purpose at the offices of the masters of the said superior courts, and to be impressed upon the writ by the proper officer of the court out of which such writ issued, upon delivery to him by the plaintiff or his attorney of a praecipe in such form as has heretofore been required to be delivered upon the obtaining of an alias writ, and a writ of summons so renewed shall remain in force and be available to prevent the operation of any statute whereby the time for the commencement of the action may be limited. And for all other purposes, from the date of the issuing of the original writ of summons. 12. Renewal of writs issued before this act. Where any writ of summons in any such action shall have been issued before, and shall be in force at the commencement of this act, such writ may at any time before the expiration thereof be renewed under the provisions of and in the manner directed by this act. And where any writ, issued in continuation of a preceding writ according to the provisions of the said Act of His late Majesty King William IV, shall be in force and unexpired, or where 1 month next after the expiration thereof shall not have elapsed at the commencement of this Act. Such continuing writ may, without being returned non est inventus, or entered of record according to the provisions of the said Act of His late Majesty King William IV, be filed in the office of the court within 1 month next after the expiration of such writ, or within 20 days after the commencement of this act, and the original writ of summons in such action may thereupon, but within the same period of 1 month next after the expiration of the continuing writ, or within 20 days after the commencement of this act, be renewed under the provisions of and in the manner directed by this act, and every such writ shall after such renewal have the same duration and effect for all purposes, and shall, if necessary, be subsequently renewed, in the same manner as if it had originally issued under the authority of this act. 13. Production of renewed writ evidence of commencement of action. The production of a writ of summons purporting to be marked with the seal of the court, showing the same to have been renewed according to this act, shall be sufficient evidence of its having been so renewed, and of the commencement of the action as of the first date of such renewed writ for all purposes. 14. Writ may be served in any county. The writ of summons in any action may be served in any county. 15. Endorsement of service to be made. The person serving the writ of summons shall, and he is hereby required, within 3 days at least after such service, to endorse on the writ the day of the month and week of the service thereof, otherwise the plaintiff shall not be at liberty, in case of non-appearance, to proceed under this Act, and every affidavit of service of such writ shall mention the day on which such endorsement was made. 16. As to service of writ on corporation and inhabitants of hundreds and towns. Every such writ of summons issued against a corporation aggregate may be served on the mayor or other head officer, or on the town clerk, treasurer, or secretary of such corporation, and every such writ issued against the inhabitants of 100 or other like district may be served on the high constable thereof, or any one of the high constables thereof, and every such writ issued against the inhabitants of any county of any city or town, or the inhabitants of any franchise, liberty, city, town, or place not being part of 100 or other like district, on some peace officer thereof. 17. Proceedings where personal service cannot be effected, but defendant knows of the writ, and evades service. The service of the writ of summons, wherever it may be practicable, shall, as heretofore, be personal. But it shall be lawful for the plaintiff to apply from time to time, on affidavit, to the court out of which the writ of summons issued, or to a judge, and in case it shall appear to such court or judge that reasonable efforts have been made to effect personal service, and either that the writ has come to the knowledge of the defendant, or that he wilfully evades service of the same, and has not appeared thereto, it shall be lawful for such court or judge to order that the plaintiff be at liberty to proceed as if personal service had been effected, subject to such conditions as to the court or judge may seem fit. 18. As to actions against British subjects residing out of the jurisdiction of superior courts. In case any defendant, being a British subject, is residing out of the jurisdiction of the said superior courts, in any place except in Scotland or Ireland, it shall be lawful for the plaintiff to issue a writ of summons in the form contained in the Schedule A. To this Act annexed, marked number 2, which writ shall bear the endorsement contained in the said form, purporting that such writ is for service out of the jurisdiction of the said superior courts, and the time for appearance by the defendant to such writ shall be regulated by the distance from England of the place where the defendant is residing, and it shall be lawful for the court or judge, upon being satisfied by affidavit that there is a cause of action, which arose within the jurisdiction, or in respect of the breach of a contract made within the jurisdiction, and that the writ was personally served upon the defendant, or that reasonable efforts were made to effect personal service thereof upon the defendant, and that it came to his knowledge, and either that the defendant wilfully neglects to appear to such writ, or that he is living out of the jurisdiction of the said courts, in order to defeat and delay his creditors, to direct from time to time that the plaintiff shall be at liberty to proceed in the action in such manner and subject to such conditions as to such court or judge may seem fit, having regard to the time allowed for the defendant to appear being reasonable, and to the other circumstances of the case, provided always, that the plaintiff shall and he is hereby required to prove the amount of the debt or damages claimed by him in such action, either before a jury upon a writ of inquiry, or before one of the masters of the said superior courts in the manner hereinafter provided, according to the nature of the case, as such court or judge may direct. And the making such proof shall be a condition precedent to his obtaining judgment. 19. As to actions against foreigners residing out of the jurisdiction of superior courts. In any action against a person residing out of the jurisdiction of the said courts, and not being a British subject, the like proceedings may be taken as against a British subject resident out of the jurisdiction, save that in lieu of the form of writ of summons in the Schedule A. To this Act annexed marked number 2. The plaintiff shall issue a writ of summons according to the form contained in the said Schedule A. Marked number 3. And shall in manner aforesaid serve a notice of such last mentioned writ upon the defendant therein mentioned, which notice shall be in the form contained in the said Schedule also marked number 3. And such service shall be of the same force and effect as the service of the writ of summons in any action against a British subject resident abroad, and by leave of the court or a judge, upon their or his being satisfied by affidavit as aforesaid, the like proceedings may be had and taken thereupon. XX Omission to insert or endorse matters in or on writ not to nullify it. If the plaintiff or his attorney shall omit to insert in or endorse on any writ or copy thereof any of the matters required by this Act to be inserted therein or endorsed thereon, such writ or copy thereof shall not on that account be held void, but it may be set aside as irregular, or amended, upon application to be made to the court out of which the same shall issue, or to a judge, and such amendment may be made, upon any application to set aside the writ, upon such terms as to the court or judge may seem fit. 21. Substitution by mistake or inadvertence of one form of writ for another may be by judge without costs, if either of the forms of writ of summons contained in the Schedule A to this Act annexed, and marked respectively Nos. 1, 2, and 3, shall by mistake or inadvertence be substituted for any other of them. Such mistake or inadvertence shall not be an objection to the writ or any other proceeding in such action, but the writ may, upon an ex parte application to a judge, whether before or after any application to set aside such writ or any proceeding thereon, and whether the same or notice thereof shall have been served or not, be amended by such judge without costs. 22. Writs for service within and without jurisdiction may be concurrent, and vice versa. A writ for service within the jurisdiction may be issued and marked as a concurrent writ with one for service out of the jurisdiction, and a writ for service out of the jurisdiction may be issued and marked as a concurrent writ with one for service within the jurisdiction. 23. Affidavits in certain cases may be sworn before a consul. Any affidavit for the purpose of enabling the court or a judge to direct proceedings to be taken against a defendant residing out of the jurisdiction of the said courts may be sworn before any consul general, consul, vice-consul, or consular agent for the time being, appointed by Her Majesty at any foreign port or place, and every affidavit so sworn by virtue of this Act may be used and shall be admitted in evidence, saving all just exceptions, provided it purport to be signed by such consul general, consul, vice-consul, or consular agent, upon proof of the official character and signature of the person appearing to have signed the same, provided always, that if any person shall forge the signature of any such affidavit, or shall use or tender in evidence any such affidavit with a false or counterfeit signature thereto, knowing the same to be false or counterfeit, he shall be guilty of felony, and shall upon conviction be liable to transportation for 7 years, or to imprisonment for any term not exceeding 3 years. Nor less than 1 year, with hard labor, and every person who shall be charged with committing any felony under this Act may be dealt with, indicted, tried, and, if convicted, sentenced, and his offence may be laid and charged to have been committed in the county or place in which he shall be apprehended or be in custody, and every accessory before or after the fact to any such offence may be dealt with, indicted, tried, and, if convicted, sentenced, and his offence may be laid and charged to have been committed in any county or place in which the principal offender may be tried, provided also, that if any person shall wilfully and corruptly make a false affidavit before such consul general, consul, vice-consul, or consular agent, every person so offending shall be deemed and taken to be guilty of perjury, in like manner as if such false affidavit had been made in England before competent authority, and shall and may be dealt with, indicted, tried, and, if convicted, sentenced, and his offence may be laid and charged to have been committed in any county or place in which he shall be apprehended or be in custody, as if his offence had been actually committed in that county or place. 24. Distringers to compel appearance or to proceed to outlawry abolished. From the time when this Act shall commence and take effect, so much of the said Act of His late Majesty King William IV as relates to the writ of distringers, and the proceeding thereon, whether for the purpose of compelling appearance or for proceedings to outlawry, shall be repealed, except so far as may be necessary for the purpose of giving effect to proceedings already taken, or to be taken after the commencement of this Act, under or by reason of any writ of distringers issued before the commencement of this Act, or under any rule or order authorizing the issuing of such writ, and made before the commencement of this Act. 25. Special endorsement of the particulars of debts or liquidated demands may be made on the writ. Special endorsement to stand for particulars of demand. In all cases where the defendant resides within the jurisdiction of the court, and the claim is for a debt or liquidated demand in money, with or without interest, arising upon a contract, express or implied, as, for instance, on a bill of exchange, promissory note, or check, or other simple contract debt, or on a bond or contract under seal for payment of a liquidated amount of money, or on a statute where the sum sought to be recovered is a fixed sum of money, or in the nature of a debt, or on a guarantee, whether under seal or not, where the claim against the principal is in respect of such debt or liquidated demand, bill, check, or note, the plaintiff shall be at liberty to make upon the writ of summons and copy thereof a special endorsement of the particulars of his claim, in the form contained in the Schedule A to this Act annexed, marked number 4, or to the like effect, and when a writ of summons has been endorsed in the special form herein before mentioned, the endorsement shall be considered as particulars of demand, and no further or other particulars of demand need be delivered, unless ordered by the court or a judge. Appearance, and proceedings in default of appearance. 26. Appearance according to provisions of Acts of 12G1C.29, and 2W4C.39, abolished. From the time when this Act shall commence and take effect, so much of a certain Act of Parliament passed in the 12th year of the reign of His late Majesty King George I, intituled an Act to prevent frivolous and vexatious arrests, and so much of the said Act of His late Majesty King William IV as relates to the entering an appearance for the defendant by the plaintiff in any action in any of the said superior courts, shall be repealed, except so far as may be necessary to support proceedings heretofore taken, and no appearance need be entered by the plaintiff for the defendant. 27. Final judgment upon writ specially endorsed in default of appearance. In case of non-appearance by the defendant, where the writ of summons is endorsed in the special form hereinbefore provided, it shall and may be lawful for the plaintiff, on filing an affidavit of personal service of the writ of summons, or a judge's order for leave to proceed under the provisions of this Act, and a copy of the writ of summons, at once to sign final judgment in the form contained in the Schedule A to this Act annexed, marked number 5. On which judgment no proceeding in error shall lie, for any sum not exceeding the sum endorsed on the writ, together with interest at the rate specified, if any, to the date of the judgment, and a sum for costs, to be fixed by the masters of the said superior courts, or any 3 of them, subject to the approval of the judges thereof, or any 8 of them, of whom the Lord Chief Justices and the Lord Chief Baron shall be 3, unless the plaintiff claim more than such fixed sum. In which case the costs shall be taxed in the ordinary way, and the plaintiff may upon such judgment issue execution at the expiration of 8 days from the last day for appearance, and not before, provided always, that it shall be lawful for the court or a judge, either before or after final judgment, to let in the defendant to defend upon an application, supported by satisfactory affidavits accounting for the non-appearance and disclosing a defense upon the merits. 28. Judgment for non-appearance where the writ is not endorsed in the special form. In case of such non-appearance, where the writ of summons is not endorsed in the special form herein before provided, it shall and may be lawful for the plaintiff, on filing an affidavit of personal service of the writ of summons, or a judge's order for leave to proceed under the provisions of this Act, and a copy of the writ of summons, to file a declaration endorsed with a notice to plead in 8 days, and to sign judgment by default at the expiration of the time to plead, so endorsed as aforesaid. And in the event of no plea being delivered, where the cause of action mentioned in the declaration is for any of the claims which might have been inserted in the special endorsement on the writ of summons herein before provided, and the amount claimed is endorsed on the writ of summons, the judgment shall be final, and execution may issue for an amount not exceeding the amount endorsed on the writ of summons, with interest at the rate specified, if any, and the sum fixed by the masters for costs, as herein before mentioned, unless the plaintiff claim more, in which case the costs shall be taxed in the ordinary way, provided always, that in such case the plaintiff shall not be entitled to more costs than if he had made such special endorsement and signed judgment upon non-appearance. 29. Appearance to be entered at any time before judgment. The defendant may appear at any time before judgment, and if he appear after the time specified either in the writ of summons, or in any rule or order to proceed as if personal service had been effected, he shall, after notice of such appearance to the plaintiff or his attorney, as the case may be in the same position as to pleadings and other proceedings in the action as if he had appeared in time, provided always, that a defendant appearing after the time appointed by the writ shall not be entitled to any further time for pleading or any other proceeding than if he had appeared within such appointed time. XXX Appearance by the defendant in person to give an address at which proceedings may be served. Every appearance by the defendant in person shall give an address, at which it shall be sufficient to leave all pleadings and other proceedings not requiring personal service, and if such address be not given the appearance shall not be received, and if an address so given shall be illusory or fictitious, the appearance shall be irregular, and may be set aside by the court or a judge, and the plaintiff may be permitted to proceed by sticking up the proceedings in the master's office without further service. And with respect to the appearance of the defendant, and proceedings of the plaintiff in default of appearance, be it enacted as follows. 31. Mode of appearance to writ of summons. The mode of appearance to every such writ of summons, or under the authority of this Act, shall be by delivering a memorandum in writing according to the following form, or to the like effect. Such memorandum to be delivered to the proper officer or person in that behalf, and to be dated on the day of the delivery thereof. 32. Proceedings mentioned in writ or notice may be had and taken. All such proceedings as are mentioned in any writ or notice issued under this Act shall and may be had and taken in default of a defendant's appearance. 33. Proceedings where only some of the defendants appear to a writ specially endorsed. In any action brought against two or more defendants, where the writ of summons is endorsed in the special form hereinbefore provided, if one or more of such defendants only shall appear, and another or others of them shall not appear, it shall and may be lawful for the plaintiff to sign judgment against such defendant or defendants only as shall not have appeared, and, before declaration against the other defendant or defendants, to issue execution thereupon, in which case he shall be taken to have abandoned his action against the defendant or defendants who shall have appeared. Or the plaintiff may, before issuing such execution, declare against such defendant or defendants as shall have appeared, stating, by way of suggestion, the judgment obtained against the other defendant or defendants who shall not have appeared, in which case the judgment so obtained against the defendant or defendants who shall not have appeared shall operate and take effect in like manner as a judgment by default obtained before the commencement of this Act against one or more of the several defendants in an action of debt before the commencement of this Act. 34. Non-joinder and misjoinder of plaintiffs may be amended before trial. It shall and may be lawful for the court or a judge, at any time before the trial of any cause, to order that any person or persons, not joined as plaintiff or plaintiffs in such cause, shall be so joined, or that any person or persons, originally joined as plaintiff or plaintiffs, shall be struck out from such cause, if it shall appear to such court or judge that injustice will not be done by such amendment, and that the person or persons, to be added as aforesaid, consent, either in person or by writing, under his, her, or their hands, to be so joined, or that the person or persons, to be struck out as aforesaid, were originally introduced without his, her, or their consent, or that such person or persons consent in manner aforesaid to be so struck out. And such amendment shall be made upon such terms as to the amendment of the pleadings, if any, postponement of the trial, and otherwise, as the court or judge by whom such amendment is made shall think proper, and when any such amendment shall have been made. The liability of any person or persons, who shall have been added as co-plaintiff or co-plaintiffs, shall, subject to any terms imposed as aforesaid, be the same as if such person or persons had been originally joined in such cause. 35. Non-joinder and misjoinder of plaintiffs may be amended at the trial, as in cases of amendments of variances under 3 and 4 W4C.42. Joinder of parties. And with respect to the joinder of parties to actions, be it enacted as follows. In case it shall appear at the trial of any action that there has been a misjoinder of plaintiffs, or that some person or persons, not joined as plaintiff or plaintiffs, ought to have been so joined, and the defendant shall not, at or before the time of pleading, have given notice in writing that he object to such non-joinder, specifying therein the name or names of such person or persons, such misjoinder or non-joinder may be amended, as a variance, at the trial by any court of record holding plea in civil actions, and by any judge sitting at nisi prius, or other presiding officer, in like manner as to the mode of amendment, and proceedings consequent thereon, or as near thereto as the circumstances of the case will admit, as in the case of amendments of variances under an Act of Parliament passed in the session of Parliament, held in the 3rd and 4th years of the reign of His late Majesty King William the 4th, intituled an Act for the farther amendment of the law, and the better advancement of justice, if it shall appear to such court, or judge, or other presiding officer, that such misjoinder or non-joinder was not for the purpose of obtaining an undue advantage, and that injustice will not be done by such amendment, and that the person or persons, to be added as aforesaid, consent, either in person or by writing, under his, her, or their hands, to be so joined, or that the person or persons, to be struck out as aforesaid, were originally introduced without his, her, or their consent, or that such person or persons consent, in manner aforesaid, to be so struck out, and such amendment shall be made upon such terms as the court, or judge, or other presiding officer, by whom such amendment is made, shall think proper, and when any such amendment shall have been made, the liability of any person or persons, who shall have been added as co-plaintiff or co-plaintiffs, shall, subject to any terms imposed as aforesaid, be the same as if such person or persons had been originally joined in such action. 36. Upon notice or plea of non-joinder of plaintiffs, proceedings may be amended. In case such notice be given, or any plea in abatement of non-joinder of a person or persons as co-plaintiff or co-plaintiffs, in cases where such plea in abatement may be pleaded by the defendant, the plaintiff shall be at liberty, without any order, to amend the writ and other proceedings before plea, by adding the name or names of the person or persons named in such notice or plea in abatement, and to proceed in the action without any further appearance, on payment of the costs of and occasioned by such amendment only, and in such case the defendant shall be at liberty to plead de novo. 37. Misjoinder of defendants may be amended before or at trial. It shall and may be lawful for the court or a judge in the case of the joinder of too many defendants in any action on contract, at any time before the trial of such cause, to order that the name or names of one or more of such defendants be struck out, if it shall appear to such court or judge that injustice will not be done by such amendment, and the amendment shall be made upon such terms as the court or judge, by whom such amendment is made, shall think proper, and in case it shall appear at the trial of any action on contract that there has been a misjoinder of defendants, such misjoinder may be amended, as a variance, at the trial, in like manner as the misjoinder of plaintiffs has been hereinbefore directed to be amended, and upon such terms as the court, or judge, or other presiding officer, by whom such amendment is made, shall think proper. 38. Upon plea in abatement for non-joinder of defendants, proceedings may be amended. In any action on contract where the non-joinder of any person or persons as a county defendant or co-defendants has been pleaded in abatement, the plaintiff shall be at liberty, without any order, to amend the writ of summons and the declaration, by adding the name or names of the person or persons named in such plea in abatement as joint contractors, and to serve the amended writ upon the person or persons so named in such plea in abatement, and to proceed against the original defendant or defendants, and the person or persons so named in such plea in abatement, provided that the date of such amendment shall, as between the person or persons so named in such plea in abatement and the plaintiff, be considered for all purposes as the commencement of the action. 39. Provision in the case of subsequent proceedings against the persons named in a plea in abatement for non-joinder of defendants. In all cases after such plea in abatement and amendment, if it shall appear upon the trial of the action that the person or persons so named in such plea in abatement was or were jointly liable with the original defendant or defendants, the original defendant or defendants shall be entitled as against the plaintiff to the costs of such plea in abatement and amendment, but if at such trial it shall appear that the original defendant or any of the original defendants is or are liable, but that one or more of the persons named in such plea in abatement is or are not liable, as a contracting party or parties, the plaintiff shall nevertheless be entitled to judgment against the other defendant or defendants who shall appear to be liable, and every defendant who is not so liable shall have judgment, and shall be entitled to his costs as against the plaintiff, who shall be allowed the same, together with the costs of the plea in abatement and amendment, as costs in the cause against the original defendant or defendants who shall have so pleaded in abatement the non-joinder of such person, provided that any such defendant who shall have so pleaded in abatement shall be at liberty on the trial to adduce evidence of the liability of the defendants named by him in such plea in abatement. XL. Joinder of claims by husband and wife with claims in right of husband. In any action brought by a man and his wife for an injury done to the wife, in respect of which she is necessarily joined as co-plaintiff, it shall be lawful for the husband to add thereto claims in his own right, and separate actions brought in respect of such claims may be consolidated, if the court or a judge shall think fit, provided that in the case of the death of either plaintiff such suit, so far only as relates to the causes of action, if any, which do not survive, shall abate. XLI. Different causes of action may be joined, but separate trials may be ordered. Causes of action, of whatever kind, provided they be by and against the same parties and in the same rights, may be joined in the same suit. But this shall not extend to replevin or ejectment, and where two or more of the causes of action so joined are local, and arise in different counties, the venue may be laid in either of such counties, but the court or a judge shall have power to prevent the trial of different causes of action together, if such trial would be inexpedient, and in such case such court or judge may order separate records to be made up, and separate trials to be had. XLII. Questions of fact may, after writ issued, by consent and leave of a judge, be raised without pleadings. where the parties to an action are agreed as to the question or questions of fact to be decided between them, they may, after writ issued, and before judgment, by consent, and order of a judge, which order any judge shall have power to make, upon being satisfied that the parties have a bona fide interest in the decision of such question or questions, and that the same is or are fit to be tried, proceed to the trial of any question or questions of fact without formal pleadings, and such question or questions may be stated for trial in an issue in the form contained in the Schedule A to this Act annexed, marked number 6, and such issue may be entered for trial and tried accordingly in the same manner as any issue joined in an ordinary action, and the proceedings in such action and issue shall be under and subject to the ordinary control and jurisdiction of the court, as in other actions. XLIII agreement may be entered into for the payment of money and costs according to the result of the issue. The parties may, if they think fit, enter into an agreement in writing, which shall not be subject to any stamp duty, and which shall be embodied in the said or any subsequent order, that upon the finding of the jury in the affirmative or negative of such issue or issues, a sum of money fixed by the parties, or to be ascertained by the jury upon a question inserted in the issue for that purpose, shall be paid by one of such parties to the other of them, either with or without the costs of the action. XLIV judgment to be entered according to the agreement, and execution issued forthwith, unless stayed. Upon the finding of the jury in any such issue, judgment may be entered for such sum as shall be so agreed or ascertained as aforesaid, with or without costs, as the case may be, and execution may issue upon such judgment forthwith, unless otherwise agreed, or unless the court or a judge shall otherwise order for the purpose of giving either party an opportunity for moving to set aside the verdict, or for a new trial. XLV proceedings upon issue may be recorded. The proceedings upon such issue may be recorded at the instance of either party, and the judgment, whether actually recorded or not, shall have the same effect as any other judgment in a contested action. Joinder of causes of action. And with respect to joinder of causes of action, be it enacted as follows. Questions by consent without pleading. And for the determination of questions raised by consent of the parties without pleading, be it enacted as follows. XLVI questions of law may be raised after writ issued, by consent, and c. without pleading. The parties may, after writ issued, and before judgment, by consent, and order of a judge, state any question or questions of law in a special case for the opinion of the court, without any pleadings. XLVII agreement as to payment of money and costs, according to judgment upon special case. The parties may, if they think fit, enter into an agreement in writing, which shall not be subject to any stamp duty, and which shall be embodied in the said or any subsequent order, that upon the judgment of the court being given in the affirmative or negative of the question or questions of law raised by such special case, a sum of money, fixed by the parties, or to be ascertained by the court, or in such manner as the court may direct, shall be paid by one of such parties to the other of them, either with or without costs of the action, and the judgment of the court may be entered for such sum as shall be so agreed or ascertained, with or without costs, as the case may be, and execution may issue upon such judgment forthwith, unless otherwise agreed, or unless stayed by proceedings in error. XLVII costs to follow the event, unless otherwise agreed. In case no agreement shall be entered into as to the costs of such action, the costs shall follow the event, and be recovered by the successful party. XLIX fictitious and needless averments not to be made. All statements which need not be proved, such as the statement of time, quantity, quality, and value, where these are immaterial, the statement of losing and finding, and bailment, in actions for goods or their value, the statement of acts of trespass having been committed with force and arms, and against the peace of Our Lady the Queen, the statement of promises which need not be proved, as promises in indebitatus counts, and mutual promises to agreements, and all statements of a like kind, shall be omitted. Judgment upon demurrer to be given according to the very right of the cause. Either party may object by demurrer to the pleading of the opposite party, on the ground that such pleading does not set forth sufficient ground of action, defense, or reply, as the case may be, and where issue is joined on such demurrer, the court shall proceed and give judgment according as the very right of the cause and matter in law shall appear unto them, without regarding any imperfection, omission, defect in or lack of form, and no judgment shall be arrested, stayed, or reversed for any such imperfection, omission, defect in or lack of form. Li objections by way of special demurrer taken away. No pleading shall be deemed insufficient for any defect which could heretofore only be objected to by special demurrer. LII pleadings framed to embarrass may be struck out or amended. If any pleading be so framed as to prejudice, embarrass, or delay the fair trial of the action, the opposite party may apply to the court or a judge to strike out or amend such pleading, and the court or any judge shall make such order respecting the same, and also respecting the costs of the application, as such court or judge shall see fit. LIII 4 days notice substituted for rule to declare, reply, or rejoin. Rules to declare, or declare peremptorily, and rules to reply, and plead subsequent pleadings, shall not be necessary, and instead thereof a notice shall be substituted requiring the opposite party to declare, reply, rejoin, or as the case may be, within 4 days, otherwise judgment, such notice to be delivered separately or endorsed on any pleading to which the opposite party is required to reply, rejoin, or as the case may be. Live pleadings to be dated and entered as of time of pleading, unless ordered to the contrary. Pleadings in general. And with respect to the language and form of pleadings in general, be it enacted as follows.